Okay, well, good morning, everyone, and thank you very much for attending this webinar. I hope it's going to be useful to you all. It's certainly been useful to me in reviewing the current state of play with regard to Greenbelt and recent cases. The title of this webinar is Greenbelt Release. And there's something about that title, actually, that gives away what Greenbelt is all about. It's not about the land itself. It's a policy construct. It is a constraint, a policy constraint. And we're going to be dealing with this predominantly in the forward planning context, although I expect Jonathan, when he gives his talk, will deal with other aspects as well. I'm Paul Shadarevian, a member of Cornerstone Barristers, and this morning the presentations will be from Jonathan Clay and Wayne Beglan. They will be well known to you. They are leaders in their field in the sphere of planning and environmental law, and both of them, indeed we all have, a lot of experience in Greenbelt cases, both promoting Greenbelt developments for major housing proposals and other proposals, and also promoting local plans where the areas are constrained by Greenbelt. And those are matters which we will be addressing in due course. Now, Greenbelt policy has its origins back in Ebenezer Howard's time in the 19th century. It really found expression in statute in 1938 in the Greenbelt, London and Home Counties Act in 1938. But in policy terms, we really see significant moves forward there in 1955 in Circular 4255. Even I am too young to remember that, but it says that its purpose is to check the unrestricted sprawl of built-up areas and to safeguard the surrounding countryside against further encroachment. It was then said that the government was satisfied that the only really effective way to achieve this object was by the formal designation of clearly defined greenbelts around the areas concerned. And at that time, those areas were London and the home counties, although gradually spread out to Essex and other areas as well. Now, as a construct, a policy construct, I think it would be fair to say that Greenbelt policy has been one of the most enduring, and I put quotation marks around this, successful policy constructs ever. It has endured almost unchanged until the present day. PPG 2 in 1988 stated that the fundamental aim of Greenbelt policy is to prevent the urban sprawl by keeping land permanently open. The most important attribute of Greenbelts is their openness. And we can see that that concept has barely changed. In fact, it finds expression now in the NPPF as well. Now, I put quotation marks around successful because the Greenbelt policy has its origins in times when there was less of a case for development in a major way of major towns, cities, in order to provide for much needed housing growth. Things have changed remarkably over the past 10 years in terms of the competing imperatives. On the one hand, to maintain openness around towns, but at the same time, to provide sufficient supply of land to provide for objectively assessed housing needs in a time of great shortage. And that tension, particularly in the south of England, is showing now in the way in which plans are coming about and the difficulties local planning authorities encounter when it comes to identifying land for release from this constraint in order to provide for an objectively assessed need and its buffer. Now, on that basis, I'm going to hand over first of all to Jonathan, who's going to deal with some general matters, which will be of relevance to the discussion about release. And then we will follow that with Wayne, who is going to talk specifically about local plans and the approach to be adopted there, both in terms of the stage 1 and stage 2 assessment. So on that note, if I can hand over to you, please, Jonathan.
Thank you. Well, good morning, everyone. My presentation is in fact going to take place in 3 parts. First of all, I'm going to take you through a high-level review of current policy and examine some of the policy concepts in detail. The term Greenbelt release refers to the release of land for development, and that can take place in 2 aspects really in the planning system. One is through development management, where it remains Greenbelt, but it becomes developed, notwithstanding its Greenbelt status. And the second way, which Wayne is going to address in detail, is concerned with release of land by effectively redrawing the boundaries of the Greenbelt, so as to exclude land from it. Of course, that's a 2-way process, and redrawing the Greenbelt boundary can extend the Greenbelt if it's justified. Secondly, I'm going to make some suggestions as to the problems that are being created in a world where there is a need to identify land to deliver 300,000, or depending on whose statistics you take, 300,000 new homes per annum. That's 1 million new houses by 2025, 2 million, says the National Housing Federation, by 2030, when all of our major urban conurbations are surrounded by green belt, and we are required to find sites that are sustainable in terms of their location. Just to put the 1 million new houses in context, a statistic from the Oxford Arc says that 1 million new homes will need 60 million square meters of distribution space. So think of that when you next order your whatever from Amazon. Thirdly, I'm going to go on to look at 2 recent important Greenbelt cases in a little bit of detail. The first one is a Supreme Court decision concerning development management, the development management issue of openness, fundamental concept of Greenbelt. And the second one, which is concerned with plan making, which I'm only going to touch on relatively lightly, which is concerned with the definition of exceptional circumstances. And then I'm going to hand over to Wayne Beglan, who will help you through the Greenbelt's release through the plan making system. Paul has taken us through a little of the history of Greenbelt and its definition. Sir Patrick Abercrombie, just to add to his chronology, in his Great London Plan of 1944, in suitably wartime terms, described Greenbelt as the final barrier, a fortified urban fence into which town should not be allowed to extend. That is a definition which does not seem to have stood the test of time, unlike the 1955 circular that he refers to, where checking further growth of built-up areas, preventing neighbouring towns from merging, preserving the special character of our towns, and introducing concepts of inappropriate development and very special circumstance were part and parcel of Circular 42 of 55. if you're wanting to put a Zoom quiz question together, one of the questions that you might ask is, what is the origin, which was the origin of the modern policy on green belts? And it's clearly the Circular of 55. It was the statute of 1947 that actually allowed for the provision of green belts, because that required development plans to define built-up areas and open spaces, and allowed the definition of green belts to come forward. But it isn't a statutory designation like national parks or AMB. It's not a landscape quality designation. Greenbelt does not necessarily washes over a complete range of qualities, and including very often built up sites and villages and settlements. It's a long-standing policy to provide a belt of countryside around our major urban areas. And as Paul says, the fundamental aim, as defined in the framework nowadays, is to prevent urban sprawl by keeping land permanently, and there's that magic word again, open. And its essential characteristics, openness and permanence. We probably know what permanence means. It means it's going to be there forever. Well, not quite ever, but openness, a very interesting concept, and has been the subject of judicial consideration in recent years. So there are 5 purposes for the green belt. First of all, restricting urban sprawl, preventing neighbouring towns from merging, safeguarding countryside from encroachment, and preserving the setting of historic towns. There's also the 5th one, assisting urban regeneration by encouraging recycling of derelict and other urban land. So the idea of it was to push development back into the urban areas. But when we look at its true effects, they're somewhat different. It protects land which may have very little amenity or ecological or buffer value. And it's because it does wash over indiscriminately all qualities. There isn't a quality criterion for its designation. Much of its open land is now of poor landscape quality, may have changed a great deal since 1955, and you have in certain areas, particularly on the fringes, something called horticulture, which is where it becomes cluttered with the paraphernalia that goes with equestrian uses, and also private leisure uses, plot land. So you find there are caravans and funny little sheds and odd little structures. The second thing is that it doesn't succeed, and particularly nowadays, it doesn't succeed. Since the NPPF, it does not succeed, in my view, in putting sufficient pressure on to drive development back into the urban areas to recycle previously developed land. And the government seems to have appreciated this in the most recent version of the NPPF in 2019. But the position is that what it in fact does is to put pressure on countryside beyond the green belt. And there is this leapfrogging of the green belt that goes on with housing development. And very often the land beyond the green belt has much more, or much greater intrinsic value. It also sterilizes land which is very often by definition close to jobs, actually in quite sustainable locations, urban facilities, transport nodes, in the places where you might otherwise have chosen to put new development for sustainable reasons, sustainability reasons. And it's pretty inflexible. The figure of 1.6 million hectares of land has been consistently the size of the green belt over the last 20 years. It does go up and down a little as you on a year-by-year basis. It increased a little between 2000 and 2010, and it's reduced by about 10,000 hectares, which is not very much, since 2010. So it's not a flexible use of land. 87% of it is undeveloped, and 77% of land within the Greenbelt is within 1 mile of a railway station. So very often your locational, most sustainable locations are in the Greenbelt. Has it outlived its usefulness? Well, is it leading to the creation of unsustainable new rural towns or garden cities which are remote from jobs, services and transport links? And some of the recent decisions on local plans, Braintree, Cambridge Arc, North Essex, where local plans have been found unsound because rural villages, new villages, garden villages or garden cities were in locations where they were remote from jobs and remote from good public transport links. And there is, and I hope that this is a view that's shared, actually widespread disillusionment with a planning system where land that meets all of the Greenbelt purposes is taken out of Greenbelt. So people have come to depend on it. It is still highly valued by the local communities that enjoy living in the Greenbelt. And the extent of that disillusionment can be seen in the spin-off from the Guildford decision, which Wayne is going to talk about in more detail, where most of the Conservative councillors there lost their seats on the council and were replaced by independents who'd stood on an anti-Greenbelt development platform. Having said all of that, the Greenbelt is a remarkable survivor. It's popular, especially with those that live there, and it has succeeded in preventing the development which Sir Patrick Abercrombie warned about. It has provided, in a sense, that fortified urban fence into which towns shall not be allowed to proceed. Now, there are a number of concepts which need to be understood in order to understand the development management process and how it affects the Greenbelt. And the first of those concepts is the concept of inappropriate development. What policy does is not to identify those things that are appropriate, but identifies those that are inappropriate. And sometimes decisions identify those proposals which are not inappropriate, using a double negative. Inappropriate development is development which is not to be approved except in very special circumstances, and that term, very special circumstances, has a particular meaning. Very special circumstances will not exist unless harm by reason of inappropriateness and other harm is clearly outweighed. Any harm is to be given substantial weight. So what is or is not inappropriate development? And we have 2 paragraphs in the NPPF, the 2019 NPPF, 145 and 146. 145 is concerned with new buildings, and it says that new buildings are inappropriate development, and then gives a list of exceptions. It's a closed list, but it starts with buildings for agriculture and forestry and appropriate facilities for sport, recreation, cemeteries, and burial grounds and allotments. And those have been identified as inappropriate development since 1955, in fact. Other forms of development, that is to say, those that are not buildings, are identified in 146 of the framework. And those other forms of development are they preserve openness and do not conflict with the 5 purposes. Do you remember I went through the 5 purposes of the Greenbelt? And in 147, there is of the framework, there is a further category, which is clearly meant to be flexible and considered on its own merits, but elements, it says, of many renewable energy projects are inappropriate development. So not all, clearly not all, but elements of many. It doesn't give us any further definition of how that works. And it may be that renewable energy projects are one form of use to which the greenbelt can be put in this world where we're looking for sites for development. Very special circumstances can include wider environmental benefits. Now, I said that this was a closed list in the sense that it identifies all the categories of what are the exceptions to inappropriate development. But in fact, there's a considerable amount of flexibility in the policy, as is exemplified by the trunk road improvement on the A19 in South Tyneside. If there are any of you this morning who are from the northeast, you'll be familiar with this controversial scheme, substantial enough to be submitted as a DCO application, as an NSIP under the 2008 Act, but was said by grant chaps in granting permission to be a form of local transport infrastructure which can demonstrate a need for the greenbelt location, which is one of the categories of exception under 146. So there is clearly a degree of flexibility in the language, although the list itself is fixed. Then we have this concept of openness, which has to be preserved as a prerequisite of any development being permitted or being considered to be not inappropriate in the green belt. First of all, what is it? Well, it's not a landscape characteristic. It is essentially absence of development or absence of built development. But how is it identified? How is it measured? Well, we've had the case of Samuel Smith and North Yorkshire, which I've identified here, which was heard in the Supreme Court. The context of the case was mineral extraction. And it followed on from a case in the Court of Appeal called Turner, where visual impact had been identified as being an aspect of assessment of the question of openness. That approach in Turner had been followed by Lord Justice Lindblom in the Court of Appeal, who had found it in that case that a particular inspector's report that was being challenged was defective, at least in failing to make clear to members that under government planning policy for mineral extraction in the Greenbelt, in paragraph 90, this was of the old NPPF, visual impact was a potentially relevant and potentially significant factor in their approach to the effect of the development on the openness of the Greenbelt. When it came to the Supreme Court, a different view was taken. Openness is the counterpart of urban sprawl. It's also linked to the purposes to be served by the Greenbelt. It's not necessarily a statement about the visual qualities of the land. So stopping there, the effect of the case was to turn on its head the view which had been taken previously, which was that one had to carry out an assessment of the visual qualities of the land and the effect on the visual qualities the development would have. Though it had gone on to say, the court had gone on to say, in some cases, this may be an aspect of the planning judgment involved in applying this broad policy concept. So it doesn't rule out visual qualities as being an aspect of it, but it's not an essential characteristic. Nor does it imply freedom from any form of development. Paragraph 90, which is now 146, shows that some forms of development, including mineral extraction, may in principle be appropriate and compatible with the concept of openness. And then this example is given, and this was, remember, this is a mineral extraction case. A large quarry may not be visually attractive while it lasts, but the minerals can only be extracted where they're found, and the impact is temporary and subject to restoration. Stopping there, isn't that just very special circumstances that would justify development that was inappropriate? And then the court went on further. As a barrier to urban sprawl, a quarry may be regarded in Greenbelt policy terms as no less effective than a stretch of agricultural land. There we are. See the thinking of Lord Carnwath there. Overturning another decision of Lord Justice Lindblom. And he goes on. Openness is a matter not of legal principle, but of planning judgment, that mysterious and wonderful quality that only planning inspectors can have, but lawyers cannot have. Planning judgment for the planning authority or the inspector. Paragraph 90 does not expressly refer to visual impact as a necessary part of the analysis, nor, in my view, is it made so by implication. The matters relevant to openness in any particular case are a matter of planning judgment, not law. Part of a long, so Samuel Smith is one of a long sequence of cases which we've probably all come across, where we're told this is planning judgment, it's not law. Interpretation of this, of course, interpretation of policy with Tesco and Dundee is a matter of law. But considering these issues, these are questions of planning judgment, not law. I wanted to just go back to 145, which is, and the particular exception in terms of buildings of limited infilling or redevelopment of previously developed land. There was a question from Mike Spurgeon of Peacock and Smith. Good morning, Mike. I hope you're here with us this morning. Who asked for whether there were any examples of where there was a more enlightened approach to promoting sites in the Greenbelt under the expanded definition of limited infilling in paragraph 145G of the most recent NPPF. It changed from the 2012 NPPF, and it added in this new proviso that development which did not cause substantial harm, and I underline and highlight the word substantial because the normal test is any harm to the Greenbelt is or to openness causes inappropriateness. But here it's substantial harm to where you're reusing previously developed land and contribute to an identified affordable housing need within the area of the local planning authority. And you can compare that with the exception under 145F, which is limited affordable housing for local community needs under policy set out in the development plan. And compare it with 144, which says substantial weight would be given to any harm. So it's clearly an exception to that proposition. There is I have come across an example because I was involved in one in Bromley where we got permission for housing site in the Greenbelt. It was for 100% affordable housing on a Greenbelt site, and we got it through on 145G. We also had asked for it to be considered under 145F, but there were no policies set out in the development plan. And we said that that shouldn't inhibit permission being granted for limited affordable housing for local community needs. But the inspector found that we didn't fall within that one, but as we fell within 145G, that permission was granted. Now I want to move on briefly, and I'm going to be very careful here not to tread on too many toes with what Wayne is going to talk about, because he's going to be going into release in a great deal of detail. but just wanted to, for completeness really, deal with the question of extension of green belts or the extent of green belts. New green belt and alteration of existing green belt takes place through the preparation and updating of strategic policies in plans, through the local plan system, effectively. But there is a justification for release here, which is different from the very special circumstances test that's used in development management, and that is the term exceptional circumstances. It is a lesser test than very special circumstances, and the key case, and it's a very important case for anyone that is doing a local plan which involves the green belt. In fact, with anyone doing a local plan needs to look at Compton and other parish councils. There are 3 parish councils involved, Compton Parish Council and Guildford Borough Council. In that case, they referred to the test for exceptional circumstances. The difference is clear enough from the language itself, said Sir Duncan Ouseley, and the different contexts in which they appear. But if authority were necessary, it can be found in the Luton and Bedfordshire Council case in the Court of Appeal. Now, I'm not going to read out, you'll be delighted to hear what Duncan Ouseley said, but I've put it on the slide so that if you want to see the key findings that he made in that particular case, they are on the slide, and they're on that slide, and they're on a further slide, which is, oh, there are 2 slides. And I hope that they're useful to you. Just in short, 3 parish councils challenged the release of land from the green belt and allocation for development in the Guildford local plan, strategy and sites plan, which had been adopted by Guildford Borough Council. So the challenges were brought under section 113 of the 2004 Act, which has the usual familiar grounds of not within the powers and procedural requirements not complied with. But the main issue here was whether the inspector who'd heard the public examination of the plan and who had proposed the release of the sites and their allocation in the plan had erred in law in his approach to exceptional circumstances that are required to justify the redrawing of green belt boundaries. And the key to the case was whether the redrawing in redrawing the boundaries to allow for 4,000 houses over and above that which was required by Guildford's OAN, objectively assessed need, amounted to or was capable of amounting to exceptional circumstances. And in that case, Sir Duncan Ouseley found that it was justified and that it fell comfortably within the term exceptional circumstances. Now, I'm going to leave the detail of that to Wayne Beglan, who's following me on in a minute, because he's going to be talking about that case in the context of release of Greenbelt. Thank you very much indeed.
Thank you very much, Jonathan. I should have said at the beginning, actually, that if you wish to ask questions, anyone, there's a Q&A button at the bottom of your screen, and you can ask questions there. We have some already. I'm going to move over to you, Wayne, to present the second part of this seminar. Thank you.
Thanks very much, Paul, and good morning to everyone who's with us. Jonathan still has control over the slides, so every now and again I'm going to ask Jonathan to advance the slides. And if we could move across to the next slide now, I'm going to talk about 3 things this morning. The first being what I see as being some key changes in government guidance between the 2012 NPPF and 2019. Secondly, what one can take away from some of the more recent inspectors' reports into local plans. And for those purposes, I'm going to use an example from each of the 3 preceding years. And then thirdly, just to do a little bit about potential pitfalls that arise in relation to Greenbelt assessment based on experiences that we have had over the last few years at examinations. So if we can go a couple of slides forward, just over the title slide, and first of all to consider some of the differences that arise between the two sets of guidance. One of the things that is clear from the Samuel Smith case that Jonathan referred to is what has been identified by the Supreme Court as a remarkable consistency of Greenbelt guidance over time. And in terms of the authorities that it's useful for any practitioner to have at their fingertips for local plan examination purposes, I would suggest those that Jonathan has identified, the Samuel Smith case, together with, of course, Calverton and Compton, because of the more discursive judgment dealing with what can amount to exceptional circumstances in that case. And Jonathan set them out very clearly in his slides. And that guidance, to my mind, is the most useful guidance going forward at the moment. And I would add to that list another case that I'm going to develop just a little later on in the slides, which is the very recent Leeds case of this year. But those four cases together give quite a helpful overview of a large number of the principles that are in play at the moment at local plan examinations. But those principles are now in play, as I suggest in my slide, in circumstances where it's become quite clear that the green belt is under pressure, perhaps as never before, as a result of two things. Firstly, the objectively assessed needs for housing being successively ramped up as a result of the approach to calculating housing need. And there's obviously an interesting, very recent development there in terms of the 2018 projections and what they may mean going forward. And that's something that a number of local planning authorities are grappling with as we speak. But also that historically, and as Jonathan pointed out, an important part of Greenbelt policy was to try and seek to direct development towards the urban areas, and in particular towards underutilised land, previously developed land. And a number of authorities have been very successful in previous iterations of their local plans in using those kinds of areas. But the reality is that for most local authorities now, those areas are increasingly scarce, and so they are having to look at different options in order to accommodate the significant numbers of housing that are still required under government guidance, where meeting objectively assessed need is a centrepiece of the proper application of that national guidance. So if we can move on to the next slide, what I've done is to indicate what seem to me to be some interesting differences between the 2012 and 2019 guidance. And the first point to note is that within the 2012 guidance, there is no definition of exceptional circumstances per se, but what that guidance does make clear, and this has been consistent over time, is that if there is to be a test of whether or not Greenbelt boundaries should be redrawn so as to facilitate development in the Greenbelt, then the appropriate time for that to take place is through the examination of the local plan. So that's why there is so much focus on consideration of Greenbelt issues during the development of emerging local plans. And the third point to note, and it's interesting that it comes in paragraph 84 of the 2012 NPPF, is that once an authority has already decided that exceptional circumstances are present, then in terms of how the boundaries are redrawn, it's at that stage that the guidance is explicit as to taking into account sustainable patterns of development. And it's an interesting feature of the guidance that that criterion doesn't appear earlier in deciding whether or not exceptional circumstances actually exist. But there's no doubt, following the guidance that Mr. Justice Ousley gave, that the ability to potentially improve spatial distribution or do something that's consistent with a sustainable pattern of development is capable of being part and parcel of the case based on exceptional circumstances. But when we turn to the 2019 guidance, what we do have is now a partial definition of what may constitute exceptional circumstances, but it's plainly not intended to be exhaustive. It works by way of a threshold or gateway into exceptional circumstances. What the guidance also indicates more clearly, and again, this is consistent with what Jonathan said earlier about government recognising that perhaps Greenbelt has been too easily used in the past, is that there is a need to fully evidence and justify any decision to go into the Greenbelt for new development. But then we get to what is genuinely new in the 2019 guidance, and it's contained mostly in paragraph 137, but also partly in paragraph 138, which has a new element as well. And that contains what I would describe as a threshold test for whether or not exceptional circumstances can exist. So if we turn on to the next slide, what we can see is that there is a clear statement of what is required to be met before there can even be consideration of whether or not exceptional circumstances are made out. So this is a test that is put to the local planning authority for consideration within the emerging local plan. Before concluding that exceptional circumstances exist, they have to demonstrate that they have examined fully all other reasonable options for meeting identified need for development. So that there are two clear points that arise from that. First of all, in Greenbelt cases, and it's an interesting contrast with the changes that have been made to the soundness tests in terms of strategy, whereas those who follow the guidance will know that an important change in the 2019 guidance was the idea that a local planning authority only has to have an appropriate strategy rather than the, as it were, best strategy going forward. But that may not be the same in relation to cases that involve significant incursion into the Greenbelt. There may be a need for a more intensive consideration of the alternative strategies, alternative options that may be available. And also those have to be options that will be sufficient for meeting identified need. So there's no particular indication in paragraph 137 that anything less than meeting identified need will be sufficient under paragraph 137 at any event. When we go back to the earlier passages of the NPPF, in particular paragraph 11 containing the overarching test for decision making and plan making, then what we see is that Greenbelt can be a reason for doing less than meeting objectively assessed needs, but only where the presence of Greenbelt provides a clear reason for not meeting those needs. So certainly one reading of that guidance, and the way that it perhaps most naturally is read, is that it's not enough to simply say, well, that there's a lot of Greenbelt within my local planning authority. What needs to be demonstrated, and this is wholly consistent with the approach that's taken to analysing harm that occurs by removal of Greenbelt, is to say that there needs to be a clear reason why the Greenbelt land should not be used in order that the objectively assessed needs can be met in full. So the paragraph 137 goes on to provide three criteria by which there is to be an analysis of whether or not exceptional circumstances might exist. And so if we move on to the next slide, we can see those three criteria. The first is simply that there should be a strategy which makes as much use as possible of suitable brownfield sites and underutilised land. Now, of course, it will be for the local planning authority in the first instance to reach its own judgment as to what land is suitable and what land is not suitable to be brought forward as brownfield sites. But it's interesting that the guidance requires as much use as possible of that land. Criteria B I've set out there, but we deal with that in a little more detail in the next slide. So I'll just leave those to read it for the time being. And then C is a duty to cooperate point, which was dealt with within an earlier webinar. But it's the point that where there is a potential for the use of Greenbelt land, then there needs to be close consideration to the duty to cooperate with neighbouring authorities to demonstrate that there have been sufficient discussions there about where unmet need might be met outside of the Greenbelt, which can be demonstrated through the provision of a statement of common ground to the examination. And so moving on to the next slide, we can see criterion B in a bit more detail, and I've put it in the left-hand box with some underlining. And to note what the potential consequences of this new policy shift are. And it's certainly a policy which seems designed to ensure that any incursion into the greenbelt is as limited in local plan terms as can sensibly be made. So it requires, in a way that is quite a shift from the 2012 guidance, a more explicit consideration of density of development, and that is to be done in line with the policies in Chapter 11 of the framework. And as I've set out in the right-hand box, Chapter 11 deals with the making effective use of land, and paragraph 123 within that chapter addresses specifically the situation that arises where there is a shortage of available land. And in those circumstances, three particular points arise. The first is that whether or not there has been optimization of the amount of development that might occur on those sites will be tested robustly. Those are the words of the NPPF itself at examination. So that may well lead to inspectors feeling that they are entitled and perhaps obliged to carry out a more intensive examination about the prospective yields of a site, what level of design, what level of scale of development might be appropriate, in particular on larger sites, during the examination process. And the steps that are taken in relation to the strategy should include the use of minimum density standards in certain locations, and the locations that come up consistently in that respect are those that are identified in 137 itself. It's a reference to town and city centres and other locations well served by public transport. So within those two categories of area, there is a need for considering minimum density standards. And what those standards should do is also prescribed now by the guidance. What those standards should do is to seek a significant uplift in the average density for an area. So that's the standing position on what should happen, rather than an approach which requires the use of greenbelt land, unless there are strong reasons why that's not appropriate. And those who read the whole of Chapter 11 will see that the guidance acknowledges that that may well lead to limitations on the ability of development at a higher density to provide the same kinds of amenity conditions that could be provided at lower density development, in particular in relation to the amount of daylight that might be received by those properties and so on. So that is a very clear shift in terms of the prescriptive nature of the 2019 guidance, away from development which might be thought to be unnecessary in the green belt. So moving across to the next slide, we can see 138 is also new in part, and so I focus on where it is in fact new. And this paragraph applies where the local authority has concluded that it's necessary to release greenbelt land for development, and it gives an idea of where first consideration should be given to the potential release of that kind of land. And it uses the same formulation that we've just looked at, dealing with previously developed land or land that's well served by public transport. And it also sets out something new compared to the 2012 NPPF, which is the idea of compensatory improvements. But when we look at those compensatory improvements, there's no indication within paragraph 138 that, for example, a commensurate expansion of the greenbelt elsewhere is looked upon as being something that should be used by way of compensation. More, it's that the remaining part of the greenbelt should be improved in the ways that are described by the criteria. And so again, we see a more prescriptive approach coming from central government in relation to how these issues of greenbelt should be approached. And then moving on, we turn to consider, as I said earlier, three recent examinations over the last 3 years. And so the first of those, if we move on to the next slide, is Runnymede, with the inspector's report from earlier this year. And the Runnymede inspector's letter is a useful one because it contains, to my mind, a number of clear statements dealing with the correct principle and approach to examinations, albeit under the 2012 guidance. And what it does, even there, applying that guidance consistent with the other inspectors' reports we'll look at, is place an emphasis on the potential use of greenbelt land to ensure needs are being met across the local planning authority. And you can see that in the paragraph numbers of the report that I've identified there. And just pausing for a second to get a feel for the nature of the three authorities that we are discussing, Runnymede is some 79% greenbelt. Guildford, that I'll turn to next, is 89% greenbelt, and Waverley, the third of my examples, is 61% greenbelt. So even in relation to two cases, Runnymede and Guildford, where the proportions of greenbelt were really quite high across the authority area, there has still been a very clear emphasis by inspectors on using that greenbelt land if that becomes necessary in order to ensure that needs are met. But what the Runnymede judgment does is emphasise that greenbelt assessment relies on a sequence of planning judgments, really from the start of that exercise, when you're talking about what kinds of parcels ought to be identified, why, what boundaries ought to be used, how they contribute to each of the five purposes, whether or not the fifth purpose is really useful for the authority in question to consider in comparative terms. All of those kinds of questions are questions of planning judgment. And the Runnymede decision indicates quite clearly that the approach that ought to be taken to those kinds of issues are to test them within the examination process. Firstly, not by asking whether or not the inspector, if the inspector was making his or her mind up for themselves, might have reached a different conclusion, but to ask if the judgment of the local authority was reasonable, and if it was a judgment that was based on a proportionate evidence base, not an evidence base that inevitably by the time of the examination may well have been improved in one respect or another. And so I've given the paragraph references for where those tests can be found, but it's interesting in the Runnymede report that really that theme flows through all of the statements that are made by the inspector. So I think it's quite a useful report from that perspective. And there's also, finally, the guidance that when you're testing plans against the fourth test of soundness, consistency with national policy, it's not a nitpicking exercise to look and see whether or not there may be one idea or concept within the plan that is not wholly consistent with national policy. A more pragmatic and better approach, perhaps, is to stand back and look holistically at whether or not the plan complies with the overall thrust of national guidance. And that was the approach that was taken by the Runnymede inspector. So moving across to the next slide, we can see Guildford. And in relation to Guildford, an issue that is particularly interesting in light of the recent Leeds judgment came up, and it was dealt with as issue 5 by the inspector in that case, and it was whether the strategic case for greenbelt release was still sound, bearing in mind the headroom that existed in the Guildford local plan by the time of examination, because the Guildford housing numbers have moved around a fair amount during the course of the examination, and by the time that the inspector finally came to write his report, there was a significant level of headroom within the Guildford plan based on housing demand versus the housing supply. And so it was in that context that the inspector had to consider whether or not the greenbelt release should still take place. And he judged that it should, and there were essentially 3 reasons why he came to that conclusion. The first was that the emerging local plan represented an integrated set of proposals. So it was designed to and did hang together as a whole. So where there were significant greenbelt releases suggested, quite often they were accompanied by infrastructure improvements or had other qualities that meant that they were important to understanding how the spatial distribution would work as a whole. And that was important to the integrity of each of those sites being released. Secondly, there was the important point about the flexibility that the headroom provided to meet unexpected contingencies, whether they might be unmet need from neighbouring local planning authorities or other difficulties in housing land supply over the plan period. And he noted, of course, that the housing requirement is a minimum figure, and that point has been strengthened up in the 2019 guidance, where it's made clear beyond doubt that authorities should be planning to meet objectively assessed needs as a minimum. And then thirdly, he noted a point which a number of inspectors have noted, that where you have strategic sites in the greenbelt or slightly larger sites, then it's important that you should have a balance, a proper portfolio of sites, some of which will deliver in the shorter term, some of which will come along in the long term, and that will provide a strengthening to the trajectory of housing supply that the authority will rely on in the course of the local plan examination. And lastly, he found that there was no justification for a restriction under what was then footnote 9 in the 2012 version of the NPPF. So he found that the presence of greenbelt was not a sufficient factor to require the authority to provide less than its objectively assessed needs. So if we move on to the third and final case example of Waverley, there a number of reasons why this is quite a useful report and set of circumstances to look at. Firstly, if you're looking to put forward an evidence base in support of a local plan, or to analyse an evidence base that is there in respect of a local plan that you're interested in, the Greenbelt review that was carried out at Waverley was, as it were, singled out by the inspector as being a comprehensive and well-judged piece of work. And in that respect, one can see that that work, if it were followed in its template and the way that it approached various questions of how you define parcel sizes, how you go about attributing values of various greenbelt purposes and so on, it will provide a very useful template potentially for other pieces of work going forward. Again, similar to Runnymede, the inspector emphasised the potential use of greenbelt land for meeting needs where they couldn't be met elsewhere. And again, the issue of spatial strategy was important to the idea that it was appropriate to release greenbelt land. And there it came into sharp focus because Godalming, which was the second largest settlement in Waverley, was surrounded by greenbelt. And so without greenbelt release in relation to Godalming, it became very difficult to comply with the overall spatial distribution and strategy that the local planning authority had in mind. And then interestingly, and in response to one of the questions that we were asked prior to today's webinar, whether or not it's always necessary to have clear demarcations of where the boundary is going to change, the Waverley local plan in part 1 used an asterisk notation to give a broad indication of where those changes would be, noting that they would be finalised, as it were, and subject to further detailed analysis in the second part of the local plan, which is in train as we speak. So moving on now to the Leeds case, very recent case, which seems to have caused something of a stir in the inspectorate, because those who are acting in local plans will probably have seen a letter close to a standard letter that appears to be going out to most examinations. So that case related to the adoption of the Leeds site allocations plan. Now, Leeds is the second largest local planning authority outside London, and about 2/3 of it is a green belt. And so the allocations plan provided for the release of various greenbelt sites based on, and this is key to this case, based on a housing requirement in the order of 70,000 units, which in turn was based on a core strategy adopted in 2014. But what was happening in Leeds at the time was that a selective review was taking place of the core strategy, essentially proceeding in parallel with the SAP. And what the more up-to-date housing numbers informing that review had shown is that there was broadly a third reduction in housing need for the relevant years that the SAP examination was concerned with. So it was in those circumstances, moving across to the next slide, that the issue of whether there remained a need to release the greenbelt sites or all of the greenbelt sites based on those absolute housing figures was a main controversial issue at the SAP examination itself, and it was something that a number of the main parties focused their submissions on. The judge described it as potentially the most controversial issue within the examination. And in those circumstances, applying traditional legal principles, it was a requirement for the inspectors in their reporting to provide clear reasons for why the exceptional circumstances case was made out based on those absolute figures. And that was the essence of the failing in that case. There were 7 grounds of challenge. If we move on to the next slide, which deals with pitfalls, just before we get on to there, just to finish on the Leeds case, the reasons challenges were grounds 3 and 4, and they were both successful. There was an additional challenge that was successful under ground 7, which dealt with whether or not the inspectors had actually approached the housing arithmetic appropriately, and it was held that they hadn't because they had missed out in their assessment of the arithmetic in what they said was the most up-to-date arithmetic, two quite significant numbers, the first of which was a windfall strategic sites, or a number of strategic sites that in total added up to about 3,000 units, and also some further permissions that totaled up to about 1,000 units as well. So there was an additional failing there in relation to their arithmetic on the housing figures. But the critical part of the Leeds case relates to the requirement of inspectors to consider carefully whether or not the updated projections provide a meaningful change. And if they do, or even if they don't, if the inspector's decision is that they don't, to set out some clear reasons supporting that conclusion. And so long as inspectors do that, then they will not fall foul of the judgment in the Leeds case. And so finally, just moving across to the last slide and looking at greenbelt assessments and some pitfalls that we have seen occur over time. And I've identified four in particular for consideration. The first relates to parcel coverage, and these are in a way simple points, but worth rechecking when you're looking at your evidence base, whether you want to object to a local plan or whether you're supporting the local plan. The parcel coverage needs to be comprehensive. Consistent methodology is key, because going back to the Runnymede decision, if there is a consistent methodology based on proportionate evidence where reasonable judgments have been made, then you ought to be able to expect inspectors to respect those judgments. But that methodology also needs to deal consistently with the relative contribution of greenbelt parcels. In part two of the study, there will be a natural consideration of whether or not those parcels that have been identified as potential parcels for development should be further subdivided. And it's important as well to see that that is done on a consistent basis, because experience shows that objectors to local plans quite often will try and line 2 or 3 or more sites up to suggest that there is an apparent inconsistency in the way that the methodology is operating in that respect. So those are some points relating to parcel sizes. Local purposes are used by a number of authorities in their greenbelt assessments, and it's always important to consider whether or not it's really necessary and appropriate to have a local purpose supplementing your greenbelt assessment, because inspectors will look carefully to see whether the impact of including a local purpose is to skew the assessment so that it's inconsistent with national guidance. If by the addition of the local purpose it remains consistent with national guidance, then no problem arises. But if there's a risk of inconsistency, then plainly there need to be some clear reasons justifying that potential inconsistency or the plan risks being found unsound. The issue of visual impact, Jonathan referred to in relation to the Samuel Smith case, and it's going to be an interesting issue going forward for consultants and those who are commissioning, relying on criticising greenbelt assessments, the extent to which an overemphasis on visual impact within an assessment might now be a legitimate feature of criticism within the examination process, and that's something that will plainly have to be worked through in light of the developing case law. And then lastly, the sustainability appraisal dimension. How is the greenbelt assessment factored into site selection? I've seen a number of evidence bases in local plans where that stage of the analysis is not always clear quite how the greenbelt assessment has been factored in. And so that's a key point to consider in either developing or looking to critique the evidence base surrounding a local plan. And in light of the changes to the guidance that I've identified, it seems to me that it may well now be sensible within any sustainability appraisal to have a separate strategy identified quite explicitly, which deals with the idea of a reasonable alternative being no greenbelt development whatsoever. Now, a number of essays already do that, but as it seems to me, that may well be an important feature of sound essays moving forward into the future. So there are some thoughts about the changes in guidance, what can be taken away from some of the more recent examinations, and some of the key points perhaps in relation to greenbelt assessment. Thank you very much. Thank you, Paul.
Thank you very, very much indeed, both of you. Thank you very much for that clear exposition from each of you. We do have some questions. I'm going to, we're running out of time, but I'm going to address a couple of them, if I may. Laura Burke says, I'm sure you're already aware that New Forest District Council have just adopted their local plan, and this has removed land from the Green Belt and allocated strategic sites for housing in areas which were considered to be performing poorly in Green Belt terms. Now, I want to, that's a statement, I'm sure you're aware, but there's one question I want to ask you, I think it is Wayne, about Green Belt assessments as part of the local plan preparation process. And that is their function within that process, where you have a coincidence of poorly performing Greenbelt sites and the fact that they are sustainable for development. I suppose the answer is clear that the Greenbelt assessment assists in that process and identifying those sites, and you're saying in Greenbelt terms they don't function so well, so there is a greater, as it were, justification for releasing them. But in authorities where there are few, if any, poorly performing Greenbelt sites which are useful for development, what is the purpose or function of a Greenbelt assessment in that context if the decision is that you've got to go into the Greenbelt to meet your OAM?
Yeah, well, Paul, I think what's being described there is the interface between whether or not there should be any incursion into the Greenbelt in order that the needs are met in full. And so the circumstances you're describing are the kinds where it would certainly be open to a local planning authority to say, well, look, we have conducted our Greenbelt assessment. We're not assuming that the Greenbelt has all of the qualities that it had the last time that we looked at this. We've looked at it again in detail and applying the most up-to-date guidance. But what we have concluded is that each parcel of the Greenbelt, which might conceivably come forward as being otherwise sustainable development, it shouldn't be made available because it serves one of the purposes of the Greenbelt, or perhaps more than one of the purposes, at least to a sufficient degree, perhaps to a very powerful degree. And it's in those circumstances where unusually an inspector ought to accept that the natural consequence of giving the protection of the Greenbelt great weight, which is what national policy requires to happen, means that there is a clear reason applying the 2019 NPPF for not meeting the full level of objectively assessed need. And so that's where I think it comes in. A point I was trying to lay emphasis on is the idea that for auditing purposes, inspectors will want to see quite carefully how that decision-making is being factored in to the overall site selection process. And so that's absolutely key, how the Greenbelt assessment can be demonstrated to have been taken into account in that way.
That's right. And to, I suppose, preclude the possibility that a failure to carry out a proper Greenbelt assessment leaves in doubt whether or not the strategy is the correct one.
Yeah, quite.
Exactly. Okay, thank you for that. Richard Knox-Johnson, a long-standing question. Morning, Richard. Where is the evidence that in the 250,000 houses planned for London's Green Belt, any of them are or will be affordable? Now, I'm not quite sure that affordability has a direct relationship with the release of Green Belt land. Affordability has been something which has been a real bugbear for the system and for society for a long time, since the 1980s, with the demise of council housing in well-planned council housing areas during the pre-war years and post-war years. Affordability is something which is only going to be affected with a dramatic increase in supply, of which the Green Belt supply will be part, but not the only answer. I don't know if Wayne or Jonathan, you have any comments on that?
I have. Shall I add a couple of words on that? Hello, can you hear me?
Yes, we can.
I mean, the problem with this issue is actually, first of all, defining what's meant by affordability. And in this context, and what is genuinely affordable? What is the evidence that any of that housing is going to be genuinely affordable? To whom is the is the question. I mean, clearly we have policy which is to support affordable housing, and one of the things which is beginning to happen is that permissions are being granted on greenbelt sites because the inability to provide housing, particularly special needs housing or housing for those for affordable housing, is a justification or part of a justification for finding that there are very special circumstances. Where is the evidence that all of that housing for London, any of them is going to be affordable? Well, it's only time will tell. I think that's all one can say. The policies, very often the policies in London boroughs do not provide a way of actually meeting affordable housing need in its entirety, and that reality has to be accepted, unless we're going to change the whole political system and go back to giving local authorities the power to build and the resources to build genuinely affordable, i.e. rented housing, affordable rented housing, and that's going to mean a political change which doesn't seem to be in the offing at the moment.
Just a short couple of observations on that question. First of all, in terms of land within the green belt, if it's also greenfield land, then experience tends to indicate that subject to infrastructure that may be required to bring a site forward, in general terms, one might assume that the viability of those kinds of sites will be slightly easier, and so there ought to be a prospect of providing a greater level of affordable housing, potentially over the policy requirements that exist. And to the extent that those kinds of developments are providing substantial contributions to acute problems of affordable housing shortage, then that's something that inspectors have recognised at a few examinations as being a factor that can be important to making out an exceptional circumstances case. So I think those two features are something that would be taken into account by any inspector looking at greenbelt release around London's greenbelt.
Okay, thank you very much. Andrew Shallis asked the question. Morning, Andrew. Where planning permission has been granted and part implemented for commercial development in the green belt, meaning the site won't remain open, and an allocation for the development is included in an up-to-date and adopted local plan, could that constitute exceptional circumstances justifying the site's removal from the green belt in the review of the local plan where the allocation is to be retained? I would have thought the answer to that is yes, but you may differ from me, Wayne or Jonathan.
Well, the problem with very special circumstances is that it depends who's making the decision. It depends on your inspector. There is no definition of very special circumstances, and it will be considered on a case-by-case basis using.
But in terms of demonstrating exceptional circumstances, the fact that the site actually is being developed and won't remain open would constitute one of those factors to be considered as to whether or not exceptional circumstances.
Absolutely, it would be certainly. They would be strong factors that one would cite as being contributing to conclusion that there were very special circumstances. You have to look at very special circumstances in the round.
And you would also have to apply the new provisions of the NPPF in looking at enhancements elsewhere, perhaps, in order to justify it too.
Yeah.
We're running out of time. Christine Lyons, do you have any case studies for early release of greenbelt before the adoption of a local plan? Now, I think, Christine, you might be referring to planning management decisions where one has to show very special circumstances. I think there are lots of examples of those up and down the country where inspectors have actually granted planning permission, found that there are very special circumstances, taking into account housing supply as one of those factors. I don't know if you want to comment on that, Wayne or Jonathan.
No, I agree. There are examples out there, and also special needs housing in particular, for example, the Tunbridge and Malling case example.
Yeah, just coming back to Andrew Shalish's question, I don't have anything to add on Christine's question, but in terms of whether or not that part implementation could be part of a case based on exceptional circumstances, and it could be, as we know, inspectors look at exceptional circumstances cases at two levels. They look at whether or not there's an exceptional circumstances case at the strategic level, whether it's caused by shortages of housing or any other particular form of need. And then they look to site-specific factors. And as it seems to me, the circumstances that Andrew is describing could be quite powerful circumstances that are locationally specific to the release of that particular parcel, on the assumption that there is a more general strategic case that could be made out for the release of greenbelt land within that authority.
Thank you. And lastly, Nigel DeWitt. Good afternoon, Nigel. He says, talking about one of the cases which was referred to, it's an important judgment because it is clear, and this is the important bit of the question, that there is no test that greenbelt land has to be released as a last resort. Is the test of last resort something which is to be considered as part of the exceptional circumstances test?
I don't know if you want me to have a first go at that, but one of the things that's helpful about the Compton case is that it recites the then recent authorities, including IM properties, and what can be distilled from that. And of course, Nigel's quite correct that under the 2012 guidance, there is no test that greenbelt land has to be released as a last resort. So the ability to go elsewhere to secure appropriate levels of land, it just becomes part and parcel of the overall assessment of whether or not exceptional circumstances exist. An interesting question, which is one for a future examination, is the extent to which the guidance that I looked at in the 2019 NPPF may require a shift to that approach that had been previously identified in both IM properties and in the Compton case. But certainly as the law stands in applying the 2012 NPPF, no, there is no test. Greenbelt land has to be released as a last resort.
I agree with that. And shall I just add to it? There's no requirement of a test of last resort. That's certainly right. There's no definition of the policy concept of exceptional circumstances in the framework. And what Sir Duncan Ouseley was keen to emphasise in Compton case was that it's really a question of planning judgment in all the circumstances, and the judiciary are very much pushing it back down onto the decision makers, those who are able to exercise planning judgment, and it's the rationality of any decision rather than the definition or criterion or some specific characteristic. Exceptional circumstances are to be considered in broad terms. So you've got a huge amount of leeway, and although there's no requirement of a test of last resort, it certainly could be a contributing factor.
Right, well, thank you very much. I'm afraid we've come to the end now. We're exceeded our time, but thank you both, Wayne and Jonathan, very much indeed. As I've said, this webinar will be available on our website, and if you have any questions arising from it, then I'm sure Wayne and Jonathan and I would welcome any further questions or queries, and we'd be very happy to do our best to answer them. So thank you very much, all of you, for joining, and I wish you a good day. Thank you.